Good afternoon and welcome to the UAW-FCA-Ford-General Motors Legal Services Plan webinar. Today's topic will be divorces. We've received a number of questions from our viewers and we've tried to incorporate as many of those as possible into our presentation. If you have a specific issue or question that you would like addressed, we encourage you to call 1-800-482-7700 and open a case with the plan. An attorney will be assigned to you who will be able to assist you. At the end of the webinar, you're going to see a short survey and we ask that you complete it. It'll only take about a minute and your feedback is important to us. So we'll start by introducing ourselves. My name is Elaine Eizelman. I'm an assistant director with the Legal Services Plan. I received my undergraduate degree from Michigan State University and my law degree from Wayne State University in Detroit. After law school, I went into private practice, handled a lot of civil litigation, including divorce cases. I joined the Legal Services Plan as a staff attorney and ultimately became an assistant director. I'm an assistant director with the new plan as well. And it gives me great pleasure to welcome Abbie Bazzi, who will be participating in this divorce webinar as well.
Thank you, Elaine. I received my degree in journalism from Wayne State University, and then I went on to law school at Wayne State University School of Law, where I received my law degree, and I practiced in the civil and criminal areas before I joined the former UAW Legal Services Plan, where I handled consumer cases, family law cases, and estate planning cases, and went on to become a managing attorney there. At the new plan, I have served as a managing attorney, and also I am now a attorney coordinator in the national office. I have over 2 decades of family law experience, and I have prepared hundreds of qualified domestic relations orders, which divide up pension benefits and 401k benefits after divorces.
Thank you, Abbie, and we're going to rely on your expertise today. Well, let's get started. I want to give you an overview of some of the things that we will be talking about today. We're going to start by talking about the process, how a divorce is filed, and how it proceeds through the court system. We'll also talk about property division, how you split up your assets, and some of the things that you should consider. We'll talk about child custody and visitation, a very difficult issue for many people. We'll also discuss child support, how it's calculated, how it's paid. And finally, we'll go through a post-judgment checklist because many people think that once their judgment of divorce is entered, everything is completed. And we can tell you that that is absolutely not true. There's a number of things that you need to take care of. So let's start by talking about the divorce process. And Abbie, the divorce process varies from state to state. We know that every state has their own rules, and a divorce is a state law process. But there are some things that are common to divorces everywhere. Maybe you can talk a little bit about the things that people could expect to see generally.
So when a person files a complaint for divorce, the complaint for divorce usually specifies certain things. Like, for example, you'd have the date of marriage in it. You would have the names of the minor children that are involved. You would also have the reason for the divorce. And most times that reason is a statutory reason. And also some states require that you lay out a proposed settlement agreement to file with the divorce complaint. And that includes property division that you have worked out with your spouse prior to filing your divorce action.
Sometimes when people file for divorce, they need to file a protective order. Can you explain that to us?
That is correct, yes. So sometimes if there's domestic abuse in a situation, a person might be able to get an order from the court that protects one party or another. And there's also an order that's very popular would be the order that prevents disbursements of assets during the pendency of a divorce case, and that would help both of the parties maintain their assets and not be afraid that the other party is going to squander the assets until the divorce action is complete.
Another thing that we sometimes see filed are interim support orders. Can you explain this a little bit?
Yeah, that's correct. So interim support orders are important when you have minor children and when you need a order from the court that specifies that one party is to pay child support to the other party so that the children can be well supported during the pendency of the action. And then there's also in order to maintain the status quo where the court can order that mortgage payments and other payments that are ordinarily paid during the pendency of the divorce continue to be paid so that the house is not lost to foreclosure or whatever due to a party's discontinuing to pay things that they normally would be paying.
Okay. So once the divorce is filed, how does the other party know that the action has been started? What kind of notice do they get?
So what happens when one party files for divorce is they have to serve the other party with the papers. So usually they would hire a process server which shows up at the door and gives the other party their papers, and then they know they're been served with divorce papers. Sometimes they get these papers by certified mail. And in some jurisdictions, a party is allowed to serve another party by alternate service if that other party is not to be found anywhere. Some parties have been separated for a long time and really don't know the whereabouts of the other party. And so the court can enter an order that allows you to serve the other party by placing a publication in a newspaper and also mailing a notice to the last known address of that individual.
And if it really is an amicable divorce, the parties are getting along pretty well and they know the divorce is going to be filed, one spouse may be able to serve the other spouse directly and have them sign acknowledgement of service.
That is correct. Yes, some jurisdictions actually allow a party to just sign an acknowledgement right on the service form saying the date and time that they received the papers and acknowledging they have received them, and that is an effective service in a lot of situations in some venues.
Okay, so let's say my spouse files the complaint or petition, not me. I'm assuming that your advice will be to call your plan attorney right away, right?
Yes, as soon as you get those papers in your hand, you should call the plan attorney right away. The reason is this: as soon as you get papers, the time starts running for you to file an answer. There is a specified amount of time prescribed by law in which you have to file an answer to the divorce complaint or a response of pleading. And that time is not very long. So talk to your plan attorney. They'll tell you what time you have to file an answer within your particular jurisdiction so that your rights are preserved, so that you do have a right to go into court and argue your case if need be. If you do not file an answer, you can be defaulted and the other party can enter a judgment with all the terms, custody, visitation, support, property divisions without your input.
What about if it's a friendly divorce and it's not going to be contested? Do I still need to file an answer?
Absolutely. You have to file an answer. The reason is this: you want to make sure that your rights are preserved so that even if things break down later, negotiations break down, you still have a right to go to court and argue your case during a trial if need be. You never want to get defaulted.
And your plan attorney, of course, can draft an answer for you and assist you with getting it filed.
Absolutely, yes. So definitely speak to your plan attorney so that he can take or she can take the next action that you need to make sure you preserve your rights.
All right, so once the petition's been filed and an answer's been filed, how long will it take for the divorce to be completed?
So every jurisdiction is different and many jurisdictions have waiting periods. For example, in Michigan, we have 60 days waiting period if you do not have children. And if you do have children, then it's 180 days for you to have your divorce case heard.
Okay. And of course, your attorney can advise you what any waiting periods are in your specific state.
Absolutely. Yes, that's one of the first things that you should discuss with the attorney, and many do, to try to figure out how long will it be before their case actually closes or finishes out.
So people might think the waiting periods are a little bit on the long side, but really there's a lot to be done during that waiting period, right?
There really is. You know, after this waiting period, this is a good time to start negotiating with the other party regarding property division and things that you want to have in the judgment of divorce. You know, include all of the important terms that you really need discussed with the other party: pension divisions, deeds to real estate, custody, visitation issues, all of that. Once you have reduced your settlement agreement, what you should do is reduce it to writing and sign it. And in a lot of cases, that is actually done by way of the judgment of divorce. A consent judgment could then be signed by the judge, and that will be the final order disposing of all of your rights.
And the judgment of divorce is actually the divorce. You are divorced once that is entered with the court.
Yes, that is the final divorce order that controls all of the rights that stem from the divorce and that discusses everything, including custody of the children, property division, pension division, and all of that. It's a very important document.
Okay, so there's a number of things we have to get done. Let's start by talking about the property division. What does that include, and does it matter what state I'm in, how my property is going to be divided?
It really does, yeah, because some jurisdictions are known as community property states, and your plan attorney can advise you about what state you're in and how property is divided there. Community property states basically consider both parties to own all of the property and that they would divide those properties equally. Now, in other jurisdictions, basically property would be divided equitably or fairly, which means that the parties can negotiate with each other to see what is fair to them or, what would make sense.
Okay. One of the biggest items when we talk about property division is real estate, and most often that's the marital home. And there are a lot of things that people need to consider when they're deciding what to do with the real estate. For example, mortgage payments.
Yeah, and that is a really, really big consideration because a lot of times real estate is one of the biggest assets that a couple owns, and there might be sizable mortgages on these properties. So when you negotiate to figure out who's going to own the property, you also want to determine if you have a mortgage and it's in your name, and you want to figure out, can you pay this mortgage if you get the house? Can you continue paying the mortgage on your salary alone? Can you pay the property taxes? Can you make the insurance payments? Can you also have the financial ability to maintain the property? And you also want to consider if you have minor children, will they be staying in the marital home? A lot of people try to get the marital home just because they want to leave the children in that home so that they have familiar surroundings until they graduate, at least from high school, so that they don't change the environmental area that they're in.
So I know that one way of dealing with the marital home is to have it sold and the proceeds divided in some way. But I think sometimes people are a little surprised as to how much they're really going to get because they think, oh, I have a $200,000 house, we'll divide it, we'll each get $100,000. But that might not be how it works out, right?
Yeah, you're right. It isn't the way it really works out because what happens is you really, what you're really getting is the net value of your house after all things are considered. Like, for example, you want to minus out the broker's commission before you sell a house. You want to minus out the closing costs and the mortgage balance, and then that'll leave you with a net value that is actually your equity in the house, and that's really what you're getting. And then you can basically use that value to, decide if you or your spouse want to swap one property for another. One person gets this versus that based on the value that you have calculated.
And that is one of the options. The house could be given or sold to one of the spouses only, right?
That's true, yeah. And a lot of times parties decide that one party will keep the house. For example, one spouse keeps the house, but they release, their claims to the other spouse's pension. You could do something like that if it's an amicable divorce, and the person that keeps the house, maybe they'll have try to have the mortgage in their name alone by refinancing the mortgage so that the other party's name is off the mortgage and they're not obligated post-divorce on this mortgage.
And that is something that is surprising to some people, is that you might give your spouse the house, but it's never refinanced, and you're still liable on that mortgage if you sign for it, right?
That's true. The mortgage company still considers you, that you owe this debt. And even if you get a divorce, you still owe the debt until the other party refinances and gets your name off of this mortgage. The issue that you don't want to run into is if the spouse who's getting the house and paying the mortgage stops paying it and then you get sued. The other problem you have if you don't get your name off of the mortgage is that you will not be able to have credit enough to get another mortgage and maybe buy another house because your name is tied to this particular mortgage.
Okay, good advice. Let's talk a little bit about personal property. Sometimes people say, oh, we really don't have anything to divide, but really there's quite a few things that people have that really are going to be divided in this divorce, right?
There really is. You have to look at the automobiles that you own, the trucks you have, the recreational vehicles, tools that you have and collections that you have. basically take an inventory of all of your personal property and your spouse's property and try to decide what is important to you. If this property is important, that you and your spouse can determine who gets this property.
And what are some of the considerations when you're dividing that property? I know valuation is a big consideration.
Yeah, it is. And basically, what you should do is the property that you are going to be receiving. Like, for example, if you're getting an automobile, what you want to do is you want to determine what is owed on that automobile, and you might want to take up the debt for it. And then you want to make sure that if your spouse is getting the automobile, that your name is not on the loan for this car, so that, at the end of the day, you end up with a net value for the property and what it's worth and what's owed on it. And also, too, if you have maybe furniture, you want to figure out which party really needs this furniture the most. One important item, too, is collectibles. And we look at, like, who spent the time acquiring those and who really appreciates them. And then there's also maybe items of sentimental value, maybe family heirlooms that have been handed down from generation to generation that may be more important to one party versus the other party.
So you really want to make your list and figure out, what do I really want to end up with, and what kind of things am I willing to maybe trade or let the other person have?
Yeah, that's definitely a good idea. Make a list, and then you could work with your spouse to figure out who gets what based on what's really important to each party and who can actually afford the item, if you can afford to keep up that item and pay the loan on it.
Okay, let's talk about some of the ways we could divide this property. Obviously, one thing is we could agree, right? We could say you take this and I take that, and that's probably the best thing. Right?
That is correct. So basically you can agree, and people do that all the time, and it's probably the best way to go. I always tell my clients, if you can decide with your spouse what to do with particular property, it's better off that way than letting a judge decide who really doesn't know you, doesn't know your family dynamics, doesn't really know how important things are to you. It's always better off that way, because at least you can live with the decision that you have made. Now, if you end up not agreeing with the other party, and then you go to court and maybe have a trial to let the judge determine the property division, you're looking at expensive court fees and attorney fees, and you're also looking at the delay in the proceedings that will prolong a divorce. It might turn it into a battle. You might not even be happy with the result, even after all of that.
We have seen a number of cases where people spend a lot of money fighting over some small amount of property, and they end up spending more than what the property was worth, and nobody's happy.
That's correct. Yes, that's correct. So it's always better off, I always tell people, if you can decide with the spouse how to divide up property, something you can live with, you're much better off.
Right. Good advice. All right, let's talk about bank accounts. Are there specific things a court might look at when dividing a bank account if you're not able to divide it yourself?
Oh, of course. So the court is going to look at, and any attorney that looks at your case is going to say, okay, so you've got some accounts. Are they held only in your name, or are they jointly held? Okay, and then who also deposited the money into those accounts? Was this coming from your paycheck, or did the other party put money into this account to try to figure out the source of that account? And also, too, an account is a very valuable asset that can be used to offset against another asset. For example, if I have an account worth $20,000, I might say, I'll keep this account, and maybe my spouse will get an automobile that's worth $20,000.
Right, right. So next we're going to talk about retirement accounts, pensions, 401ks. Oftentimes this is the party's largest asset they've saved for many years for retirement. And it really needs to be approached carefully. It's a very complicated issue. And in fact, we devoted an entire webinar to this issue, a quadro webinar, which is qualified domestic relations orders. Those are the orders that are used to divide and award retirement accounts. And I'd encourage you to check out that webinar because it gives you a lot of information. And we're not going to go through all of those things today. That would take too much time. But maybe you could talk to us about some of the factors that are considered and how this works.
Yeah, so basically division of retirement accounts, which includes pensions and also includes 401k accounts, is a very complicated process. And the court, in order to figure out, who to award retirement benefits to, would look at the length of marriage, the length of the employment of the parties, the total assets they have, and the ability that they have to support themselves, in determining who gets a specific amount from a benefit. And when that is done, we would need a qualified domestic relations order to divide that benefit and give the other party their interest. So you could always discuss all of this with your plan attorney. And I always tell people that it's always better off that they discuss retirement accounts and who's going to get what. And then we could always draft those quadros that divide those assets, and they be entered along with the judgment of divorce and then sent to the plan administrator. It's always better to do all of that now during the divorce proceeding than to wait later to do those quadros.
We do get a lot of people calling in for quadros years after they've been divorced, and generally right before they're ready to retire. And that's the reason you want to get it done when you're getting divorced, so you don't hold up your retirement process, right?
That's true. And so we get a lot of phone calls from people who are going to retire, and they say, well, my retirement date is a few weeks away, and they've told me that I can't get my retirement funds because I don't have a quadro in place, and they know I was divorced 10, 20 years ago sometimes. What you want to do is you want to talk to your plan attorney as soon as possible if you have been divorced and there's going to be a quadro division. And sometimes even if there isn't a division, you want to make sure that things are simply in place so you can have a smooth retirement. Because it does take time to prepare those quadros, get them entered by the court, and then get the plan administrator to approve them. It's not a very quick thing to do.
Right. And we actually have a question on quadros that just came in from one of our viewers. Can a quadro be changed years later?
Some quadros can be changed and some cannot be changed. They're very complicated, devices to divide retirement accounts. And so basically, if you have a quadro that's in place that you want to change, in order to get a quadro changed, you would need to go get the other party's signature if it's an amicable thing. And you would also need the judge to sign it. And then you need the plan administrator to approve it. All these things have to happen. Some quadros cannot be changed simply because of the way that the division is written up in the document itself. So if you have such a quadro, please bring it to a plan attorney so that they could look at it and advise you about what can and cannot be done.
Again, we would encourage you to call and open a case, and so somebody will be able to answer your question specifically. Okay, so we've talked a lot about the assets, but parties accumulate not only assets during the marriage, they accumulate debt. And that also has to be divided, right?
Absolutely. Debts are actually very important in a divorce judgment. The judgment needs to specify who is going to pay these debts. Sometimes, like I said before, the mortgage is a huge debt that you want to determine who's going to pay it and then do the refinancing so that one person puts it into their name. There's other debts. There's car loans. There's sometimes very big credit card debt. Those should not be overlooked. It should specify who pays those. Now, like I may have said before, even if a judgment of divorce says, like, for example, one party pays a debt, that does not relieve you from that debt obligation from, say, the credit card company, because you have an obligation to the credit card company to pay. So the best thing to do is probably have your spouse get a different loan, pay that off, and then so the debt is in their name alone and there's no loose ends lingering after a divorce is finished.
And usually the person who gets the property gets the debt that's associated with it, right?
Yes, that's true. So let's assume one party is going to receive an automobile and there's a loan on it. Usually that party will be responsible for the loan. But you want to make sure that somehow some kind of financing is done where your name is off of that car loan. You don't want to leave that lingering, like I've said.
Right, good advice. So another financial decision to be made kind of in the property settlement area is spousal support or alimony. It's not awarded as often as it used to be years ago, but it occasionally still is. and sometimes for a temporary period of time, sometimes longer. And can you talk to us about it a little bit, some of the things that go into that decision?
Yeah, so alimony or spousal support, I'd say it varies greatly, not only from jurisdiction to jurisdiction, even sometimes from county to county, depending on how those courts deal with that matter. And a lot of times a person can maybe look at an alimony award if in fact there is a big disparity between the income of the two parties. Also, you would look at, say, for the length of marriage. If you've been married for 20 years, you're probably gonna pay alimony, compared to somebody who's only been married for 1 year. You look at that, the time that you've been married. Also, too, alimony is generally set for a limited amount of time. It could be set for a number of years, 10 years. It could be set for 6 months. It's usually an amount that allows the one party who doesn't earn much to get on their feet, maybe to get an education, to get a job or the like, or at least to give them some income for some time to which they've become accustomed by the marriage that they've been married to you. So basically, when we look at alimony, we're going to look at the work history, we're going to look at the income of the parties, the assets that they have, the ability to earn. Like I said, if there's a big disparity in income, you might be looking at some alimony. And I always say, it's always better off if a person can pay alimony for a limited amount of time versus giving the other party a part of the pension benefit, which may not be for a limited amount of time.
Right. Good advice. So there's a couple other things that come up in the course of divorce proceedings, and one of those things is attorney fees, where we often think, well, everybody's responsible for their own attorney fees. There are some exceptions to that.
There really is. And so in divorce issues, we see a lot where one party earns a lot of money and the other party really, is not a big income earner. A judge has the discretion in many cases to just simply say the attorney fee for the party that doesn't earn much is going to be paid by the wage earner. That way it's reduced down to the judgment of divorce, and it specifies that the other party will be paying this party's attorney fee. And a lot of times, too, you can see that if one party takes the other party to court many times on a motion here and there for things that are really of not much merit, the court also sometimes has discretion to go ahead and award attorney fees for those motions that the party filed that really shouldn't have been filed and heard in the first place.
Abbie, a couple of our viewers asked about restoration of a name prior to a marriage, and that sometimes can be accomplished in a divorce judgment, right?
Yes, a lot of jurisdictions allow you to restore your name back to what it was before the marriage, and that's something you should discuss with your plan attorney because you want it in that order, because the divorce judgment is an order of the court, and it would say so-and-so's name is hereby restored. And then you could take that order, which is the judgment, to the Secretary of State or wherever you need to take it to get your name restored on your other documents.
And if your state permits it, that will save you from filing another action to get that name restored.
That's correct, yes. Then you wouldn't have to file, maybe a petition for name change.
Right. All right, let's move into one of the more difficult issues in a divorce, and that has to do with child custody and visitation issues. The custody of a minor child is one of the most important decisions that the parties have to make during the divorce proceedings, and hopefully not a contentious one. But even if the parties agree, we're finding that many of the courts now require some sort of class attendance on the part of both parents, and the classes discuss the effects of divorce on children and visitation issues and how to talk about the other parents. And you may be required to attend such a class in certain jurisdictions before you can get divorced. Parties can agree to a custody arrangement, and that, of course, saves time, money, emotional upheaval, better for the children, better for the parents. And, of course, if that is at all possible, we would encourage people to reach some sort of agreement. But if people don't agree, we know that they will have to go to court, and the judge will have to decide the custody of the minor children. So let's talk about that. And one of the things I think that people are sometimes confused about are the two kinds of custody, legal and physical. Can you tell us the difference between the two?
So yes, in many jurisdictions, there's a distinction made between legal custody and physical custody. Legal custody refers to the right of a parent to make decisions on behalf of a child. Those would be like medical decisions, educational decisions, like where do the children go to which doctor, and things of the sort. Now, physical custody refers to where the child will reside, which parent will the child reside with. And there's also, another type of custody, which now I see a lot more of, which is, shared physical custody, shared legal custody, where the child basically resides with both parties, hopefully an equal amount of time with each.
Can you give us an example of a shared custody arrangement?
So if you have shared custody, usually, you would have a schedule where maybe one party would have the child from Sunday morning until after school, maybe on Wednesday, and then the other parent would have the child on Wednesday through maybe Saturday night. That would work. And let me also add that, whoever has custody usually ends up getting the income tax dependent tax deduction for that child, and then if you have shared custody, sometimes I've seen parties where they basically have one parent gets the tax deduction in even numbered years, and then the other party gets it in odd numbered years, and they share it that way. That works.
If one parent is given physical custody of the child and decides that they have to move, say, for example, I'm offered a job in Texas and I want to move the minor children with me, can I do that?
Well, ordinarily, no, because most of the time, judgments of divorce usually have a clause in them that says the child may not be removed from the state that entered the divorce judgment. And in fact, some courts even have it in their judgment that says a child cannot be taken maybe farther from their home where they now live, and that is basically to make sure that the child doesn't leave the jurisdiction that they're in, and also too that the other parent doesn't lose their visitation rights by a child being taken from the state.
Right. And it's possible to have joint legal custody with physical custody in just one parent, right?
That is correct. Yes, there's a lot of situations where you have joint legal custody with physical custody vested in one of the parents, and then the other parent would have visitation.
Okay. So if the parents can't agree on custody, then the court will decide, and that can be pretty brutal. The courts will always consider the best interest of the child, and that's a standard that's used in almost every state. And the standards, the items under the best interest of the child can vary from state to state and how they're worded, but there are many factors that are used in every state, and the factors are weighed for each party, right? These factors favor this party, this factor favors the other. In the end, the judge makes a decision. Can you talk to us about some of those factors?
Yeah, so, in every jurisdiction, there's some sort of best interest calculation that's done to determine, where the children will stay, with what parents they'll stay with. And what's looked at is, maybe the age of the child, and then the child's living situation, which parent can provide appropriate housing for the children, their ability to support, clothe, feed the children, take them to school, take care of their physical needs. And then they can also look at the parent's ability to foster the relationship with the non-custodial parent. Do they speak badly of the non-custodial parent and interfere with visitation? Another factor that they would look at is how willing is that parent to take part in that child's activities, assist with after-school activities, take them to the doctor, help them with their homework. The courts also look at an established custodial relationship where, the parent and maybe has some extended family and community members, and all of this, helps the child to learn and grow. And basically the court might want to keep them in that particular environment because there is an established custodial environment. And then one more factor that they could look at would be if one of the parents has some sort of substance abuse or maybe some sort of instability. That could also factor into a decision.
Right. So a number of our viewers have asked this question, and it's one that I know we've talked about that clients ask frequently. What if my child says they want to live with me? They can't really make them live with the other parent, can they?
Well, sometimes the court is actually willing to allow a child to voice an opinion, and that is if the child and the court determines is of a particular age and maturity that the child can voice his or her opinion. And usually that's done in the judge's chambers in private, but the judge really isn't bound by what the child says, because a child might really just want to stay with one parent because they're lenient and don't make that child do homework, which really wouldn't be in the best interest of that child.
I'm sure they would disagree, but you're right. So if one parent is given physical custody, does the other parent get to see the child?
Absolutely. And that's another issue that we always address in our orders, in our judgments of divorce. Usually the non-custodial parents would have visitation that is set out in the judgment. It might actually have a specific order that says, you know, for example, the non-custodial parent gets to see the children every other weekend, maybe every alternating holiday. If you get Christmas this year, I get Christmas next year with the child, and then maybe sometime during the summer for a few weeks while the child is off on summer vacation. It could have a specific order, and sometimes when parties are really amicable with each other, they can just simply include something sometimes that says, you know, reasonable visitation to be worked out by the parties, and then that works just fine because the parties are cooperating.
Right. What if the custodial parent interferes in the visitation with the other parent, makes them the child unavailable, for example?
Yeah, I do get a lot of phone calls by parents that say the other parents will not let the child visit with me. I go to pick up the child and the child isn't there, and they do all sorts of delay tactics to make sure that the child doesn't visit with me. A party would have to actually go to court and file a motion and bring that issue before the judge. And the judge could then order that party to comply. Or the other thing that's a little drastic, but a judge could very well order that the custody be changed from one party to another party simply because of the behavior of one of the parties.
So it's in the best interest not only of the child, but of the parties as well to make the children accessible for visitation.
Absolutely.
Okay. Another tricky issue dealing with children is child support, and we have a number of people who've asked us, how do they come up with that amount for child support? I don't get it.
Okay, so child support is not really an arbitrary amount that's decided. It's basically set usually by state guidelines. And what happens is the court, or maybe even if there's a friend of the court in your state, what happens is they do an investigation sometimes, and they require that you come to the investigation, provide wage stubs and provide tax forms and whatever, you know, they ask you for. And then they basically do an evaluation to determine how much should the party pay to the other party. And those are really, like I said before, set by state guidelines. Now, there could be a reduction for a party, for example, if one of the children is receiving Social Security benefits through one of the parents, you know, and other nuances that could affect things like that.
And what about a parent who's been ordered to pay child support and maybe gets laid off or gets injured at work and is on disability? Is there anything they can do to modify that support?
Yes, they should be able to go to court and file a motion to reduce the support that they are paying. You know, they would just simply have to provide proof of all of this, you know, maybe the reduced wages, now new wage stubs, maybe a letter from their employer to let the court know what has happened in their life, that now they have a reduction, and seek that reduction in child support.
So another aspect of child support is providing for the children's health and medical care. And who's responsible for that?
Yes, and in addition to child support, the court also sets out, you know, who would be required to provide maybe employer-sponsored health insurance for the children, keep the children on their health insurance. And another aspect would be, too, to determine who would pay for unreimbursed medical expenses. Those are not covered by health insurance. And the court could very well decide that one party pays 70% of unreimbursed expenses and the other party pays 30%, and that might be due to the income disparity of the parties.
Okay. So let's say we've agreed on the property division, who's going to have the children, child support amount is decided, and the judgment of divorce is entered. That's really not the end, is it? There's many things that we need to do, and we've seen people who've forgotten to take care of many of these things, and that causes a lot of problems later. Let's talk about each of these things. Let's start with any open joint bank accounts.
Yeah, joint bank accounts are very important. Just because you received a judgment of divorce that says, the funds in a joint account are to be divided, what you want to do is divide those accounts, give the funds, split them with the other party, but you also want to make sure that account is closed. If your name remains on a bank account after a divorce is final, you are still responsible for that account. If a check is bounced by the other party, then you're responsible for those fees. You're responsible for whatever happens, and the bank will hold you accountable. So absolutely very important to close any accounts and tie up all loose ends after a judgment is entered.
Another area where we see people forget to take care of things is on beneficiaries. And beneficiaries are incredibly important, and people sometimes don't understand that who you have named as a beneficiary controls everything. Such an important topic. We actually did a webinar on, and that was another one of our webinars. And again, I would encourage you to go and look at that webinar. There's a lot of really good information in there. But briefly, in terms of a divorce, we want to make sure that people do change the beneficiaries they had listed prior to their divorce, because often it's your former spouse, right?
That's right. Yeah. So just because you have a judgment of divorce doesn't mean that you're done. You really should go to your bank, make sure that any beneficiaries designations you've named on your bank accounts are changed from your former spouse to whoever you want to name. Also, to look at your life insurance policies. You have to change those beneficiary designations. We have seen situations where people have not changed them, and really it doesn't look good when that happens. You get into a lawsuit, and then there's all sorts of ramifications that happen. Also, there's 401k plans that have to have designations changed. And don't forget any stock portfolios that you have and any other investment accounts where you have designated beneficiaries. All of those have to be looked at and changed promptly after a divorce judgment is entered.
Sometimes, Abbie, people say to us, but I changed my will, so I just thought that took care of everything. And then they die and the life insurance goes to the former spouse because...
Right, yeah, so a will does not change a beneficiary designation. In fact, any document, any account where you have a beneficiary designated, that will not go through your will anyway. That is not a probate asset. So you really need to change it. The will doesn't control those items that have a beneficiary designation.
And if you're awarded the marital home and it's going to be in your name and you're refinancing, you really need to get on that, don't you?
Yes, in fact, a lot of judgments of divorce will set a time deadline for one party. Say one party's getting the house, they should set a time deadline and say, the other party has, 90 days to refinance the mortgage on the house and get that party's name off of the mortgage so they are no longer obligated. Make sure that the other party does what they're supposed to do, or else you're going to end up back in court, and make sure that your name is off that mortgage.
And that includes if you're getting payoff funds, you want to make sure there's a time limit for the spouse to refinance and get you that money, right?
Absolutely, absolutely.
Right. And if you have any real estate, be it your marital home or maybe a vacation home, you want to make sure you're recording new deeds as well, right?
Yeah, you should definitely record new deeds. If a person is changing ownership, they should record a new deed. So if you're getting the house and your spouse's name is supposed to be off the house, plan attorney can prepare a new deed right after that judgment is done. And basically the new deed will take the name off. Both parties can sign it, and the deed would probably say something like, this deed is given pursuant to a judgment of divorce in such and such case, recorded, and then you know that you have no issues if anything happens later on.
Another concern, and we've seen this happen, where the ex-spouse gets the car, the our client has not taken his name off that car, and of course, there's an accident, and he gets sued as an owner.
That's right. Yeah, and that can happen. So just because a judgment of divorce says one person gets an automobile, doesn't end it there. You have to go to the Secretary of State and change ownership on the automobile. You don't want your name as an owner if you are actually not driving that car, because you could still, in your jurisdiction, have owner's liability. You can be sued for negligent entrustment of an automobile if there's an accident. You just don't want to be liable.
Right, important information. Then there's your employee benefits. You want to make sure that you notify your employer that you've been divorced, because there's a number of things that your employer has to do and you have to do.
That's right. So when you get a divorce, your spouse has a right to a COBRA notice, which allows them to maintain health insurance through your own plan for a specified amount of time that's specified by law. And, you want to give your former spouse's address to your employer so they can send them that notice. Another thing you want to do through your employer is make sure that all the accounts you have at your employer, like your 401k and your life insurance and everything else where you have a benefit, like maybe your health insurance, the spouse's name needs to be off all of those.
And you want to make sure that you actually complete the forms and give them to your employer, because until that happens, none of this is official, right?
It's not effective until you complete those forms and turn them in. And some people complete them and don't turn them in, which really doesn't do you any good.
Right. Another thing people sometimes forget to do is to look at their homeowner and auto insurance policies and make changes on those as well.
Yes, you really should, after a divorce, look at your insurance policies. If you have a divorce, you want to make sure your homeowner's policy knows that they're no longer an owner of this property and no longer occupying the property. Also with automobile insurance policies, you want them to know the last thing you want to do is make a claim and the check comes in both names and then try to get them to sign off on a check that has their name on it. The other issue is you don't want to make a claim and your insurance policy denies you because they say you didn't notify us of these things and that made a major change to your policy.
Right. And finally, quadros. We want to make sure that those quadros actually get completed, entered, and approved, right?
Yes, and I touched upon it a little bit before, get those done right after the judgment of divorce, or even with the judgment of divorce, you can get them entered. But make sure they are entered. Do not wait until you're ready to retire, because they do take some time to complete, because they are a little bit complicated. And then the court has to enter them, and then the plan administrator has to qualify them and approve them. So the procedure takes time. Don't hold up your retirement because of a lack of a quadro.
Right. Get it done now.
Absolutely, yeah.
Okay. Well, thank you, Abbie. You've given us a lot of valuable information and a lot of things to think about. And if you have a specific question about divorce or any other legal matter, call 1-800-482-7700. Open a case. An attorney will be assigned to you. It's your plan. We're here to help. And I want to remind you again that there'll be a brief survey at the end of this webinar, and we ask that you take the minute or so that it takes to complete it. Again, we appreciate your feedback, and thank you for being with us today. Thank you, Abbie.
Thank you.